They said she signed away her company. She said she signed something else entirely. The boardroom sat on the 47th floor. 11 chairs surrounded a table carved from a single piece of timber, dark and heavy, the kind that suggested permanence. Elena Mirren had chosen that table herself 7 years earlier, when the company was still small enough to feel like hers. Back then, it had been 4 people in a rented office, working late on prototypes that barely functioned. Now, Mirren's systems employed 2,000 people across 3 countries, and the table had become a stage for decisions that moved markets. She sat at the head of it now, her posture straight, her expression calm. Across from her sat Marcus Hale, the lead investor from Westridge Capital. He wore a navy suit that looked expensive without trying. "We're grateful for everything you've built, Elena," he said. His voice was smooth, practiced. But growth at this scale requires different leadership. The board has voted. 9-2. Elena didn't blink. She'd known the vote was coming. She'd watched the alliances form over the past 6 months, the quiet dinners, the phone calls that stopped when she entered the room. Hale had orchestrated it carefully, leveraging his 42% stake, bringing other investors into alignment with promises of returns, efficiency, streamlined operations. "I understand the vote," Elena said. Her voice was steady, but something beneath it carried weight. "What I don't understand is the claim that I agreed to step aside." Hale slid a document across the table. It was bound, professional, thick with pages. "The transition agreement, signed 14 months ago. Section 7, Clause C. It grants the board authority to initiate executive restructuring if certain performance benchmarks aren't met." Elena had read that document 100 times since receiving the legal notice. She knew every clause, every subsection, every comma. She also knew what she had signed and what she hadn't. "I signed a framework agreement," she said. "Not a transition agreement." Hale's smile was patient, almost sympathetic. "The framework became the transition. You approved the final draft. Your signature is on file." "My signature is on a framework," Elena repeated. "One that outlined potential governance changes pending mutual approval. It did not authorize unilateral removal." The room was silent. 2 other board members exchanged glances. One of them, Diane Kessler, a longtime ally, looked down at her hands. Hale straightened his cuffs. "If that's your position, then I suppose this will need to be settled formally." Elena knew what that meant. A legal proceeding, attorneys, a public dispute that would affect the company she'd spent years building. But she also knew what she'd signed, and she knew what she hadn't. "I suppose it will," she said. The meeting ended without ceremony. Board members filed out in silence, some avoiding her eyes, others nodding with what might have been respect or regret. Elena remained seated, watching the empty chairs. Diane Kessler paused at the door. "Elena, I'm sorry. I didn't think it would go this way." "You voted against me." "I voted for what I thought was best for the company." Elena looked at her. This woman she'd trusted, who'd been there since the 2nd round of funding. "And you think removing me is best?" Diane hesitated. "I think Marcus made a compelling case about scalability, about structure, about control," Elena said quietly. Diane said nothing. After a moment, she left. Elena sat alone in the boardroom. She thought about the early days, the late nights, the moment when the first product shipped and actually worked. She thought about every hiring decision, every crisis navigated, every pivot that had kept the company alive when it should have failed. She thought about the difference between building something and owning something. And she thought about the document she'd signed. The real one, the one that said mutual approval, the one that protected what she'd built from being taken without her consent. She pulled out her phone and called her attorney. "Simone," she said, "we're taking this to civil court." The courthouse was old stone, built in a time when buildings were meant to outlast the people who used them. Judge Marion Holt entered without ceremony, her robe dark and plain. She was in her early 60s, with grey hair pulled back, and a face that suggested she'd heard every argument twice. "Mirren versus Westridge Capital and the Board of Mirren Systems," she said. "Dispute over executive authority and contractual interpretation. I've reviewed the filings. Let's proceed." Hale's attorney stood first. His name was Richard Calloway, a partner at a firm that specialized in corporate governance. He was tall, composed, and spoke with the kind of confidence that came from winning often. "Your Honor, this case is straightforward," Calloway began. Ms. Mirren entered into a binding agreement that granted the board authority to initiate restructuring. She signed willingly. She participated in discussions. She cannot now claim she didn't understand the terms, simply because the outcome is unfavorable to her. He placed a copy of the document on the clerk's desk. "The transition agreement signed by Ms. Mirren on March 17th. Section 7, Clause C, explicitly allows the board to remove executive leadership if performance metrics fall below agreed thresholds. Those metrics were not met. The board acted within its rights." Judge Holt glanced at the document, then at Elena's attorney, a woman named Simone Yates. Yates was younger than Calloway, less polished, but her eyes were sharp. She rose slowly. "Your Honor, Ms. Mirren did sign a document on March 17th, Yates said. "But it was not the document Mr. Calloway is presenting. She signed a framework agreement, a preliminary outline for potential governance changes. That framework was conditional. It required further approval. It did not grant unilateral authority." Calloway's expression didn't change. The framework evolved into the final agreement. Ms. Mirren was copied on all correspondence. She participated in board meetings where the terms were discussed. Her silence constituted consent. "Silence is not consent in contract law," Yates replied, "and participation in discussions is not the same as signing a binding agreement." Judge Holt held up a hand. "I'd like to see both documents. The one Ms. Mirren claims she signed, and the one Westridge claims is binding." The courtroom fell into a waiting silence. Elena watched the judge's face, trying to read what lay behind the calm, judicial neutrality. This was the moment everything hinged on, whether the court would see the difference between what she'd agreed to and what was being claimed. Calloway cleared his throat. "Your Honor, may I add that Ms. Mirren had ample opportunity to object to the transition agreement after it was circulated. She attended 3 board meetings following its execution. She reviewed quarterly reports that referenced the agreement's terms. Her continued participation suggests acceptance." Yates responded immediately. "Attending meetings is not acceptance of a document she never signed. Reviewing reports that reference an agreement doesn't validate that agreement if her signature was obtained improperly." "Improperly?" Calloway's tone sharpened. "That's a serious allegation." "It's the truth," Yates said simply, "and we intend to prove it." Judge Holt closed the folder in front of her. "Then I suggest you do exactly that. I want a complete document trail, every email, every draft, every piece of correspondence related to both agreements. If there's a discrepancy in how these documents were created, circulated, and signed, I want to see it clearly." She looked directly at Elena. "Ms. Mirren, do you maintain your own records of what you signed?" Elena nodded. "Yes, Your Honor. I keep copies of everything. Every document I sign, I save with a timestamp and a note of the circumstances. Then submit those records along with the official documents." Judge Holt's gaze shifted to Calloway. "Mr. Calloway, I expect full cooperation from Westridge Capital in providing server logs, email archives, and any third-party signature platform data. If there are any attempts to withhold or alter evidence, this court will respond accordingly." "Of course, Your Honor," Calloway said. But Elena saw the briefest flicker of concern cross his face. The documents were placed side by side on the judge's bench. They looked almost identical. Same font, same formatting, same structure. The cover pages were different only in title. One read, Framework Agreement for Governance Review. The other read, Transition Agreement for Executive Restructuring. Judge Holt read in silence for several minutes. Elena sat still, her hands folded in her lap. She'd spent the past month preparing for this moment, reviewing every email, every draft, every note from every meeting. She knew what she'd signed, but she also knew how difficult it would be to prove. "Ms. Yates," the judge said finally, "do you have evidence that Ms. Mirren's signature appears only on the framework and not on the transition agreement?" "We have the original document she signed, Your Honor. It's dated March 17th and it bears her signature. The transition agreement presented by Westridge is dated the same day, but Ms. Mirren never saw that version before signing." Calloway stood. "Your Honor, the documents were circulated electronically. Ms. Mirren signed digitally. The signature applies to the final version, which was the transition agreement." "Do you have evidence of that digital signature pathway?" the judge asked. Calloway hesitated, just for a moment. "The electronic records show a signature on March 17th. The document in our possession is the one that was finalized." "That's not the same as proving she signed that specific document," Yates said. Judge Holt leaned back. "I'm going to need a full accounting of the document history, every draft, every email, every timestamp. If there's a discrepancy, it needs to be clear." The judge's directive hung in the air like a challenge. Elena watched Calloway's face, the slight tightening around his eyes, the way his jaw set. He'd expected this to be simple, a signature, a document, a done deal. "Your Honor," Calloway said, "we can provide server logs and email records, but I would note that Ms. Mirren's own IT department managed these systems. Any discrepancies could easily be attributed to her side." It was a careful accusation. The implication was clear. If something looked wrong, Elena might have altered it. Yates stood immediately. "That's a serious suggestion, Mr. Calloway. Are you accusing my client of tampering with evidence?" "I'm suggesting that both sides had access to the same systems," Calloway replied smoothly. "Chain of custody matters." Judge Holt raised a hand. "Noted. I'll expect complete records from both parties, including any third-party email services, cloud storage, and signature platforms. If there's been any alteration, we'll find it. Court is adjourned until those records are submitted." The gavel came down with a sharp sound. Elena stood, gathering her papers. Across the aisle, Marcus Hale was speaking quietly with Calloway, their heads bent together in conference. She couldn't hear what they were saying, but she could see the tension in Hale's shoulders. They were worried. Good. In the hallway outside, Simone Yates pulled Elena aside. "They're going to fight the metadata disclosure. They'll claim proprietary systems, privacy concerns, anything to slow this down." "Let them fight," Elena said. "I have backups of everything. Cloud storage, external drives, even printed copies with timestamps. They can't dispute what I can prove." Yates studied her. "You really did keep records of everything." "I learned early," Elena said. "When you're building something from nothing, every agreement matters. Every signature, every clause, every word. You can't afford to be careless. Most founders aren't this meticulous. Most founders lose their companies." Elena's voice was matter-of-fact. "I wasn't going to be one of them." "How long do you think this will take?" Elena asked. 3 weeks, maybe 4. They'll try to delay, but Judge Holt doesn't tolerate games. She'll push for expedited discovery." Elena nodded. 3 weeks. A month, perhaps. Time enough for doubt to creep in, for allies to waver, for questions to arise. Time enough for challenges. But also time enough for truth. "Whatever it takes," she said. The discovery process took 3 weeks. Both sides submitted files, emails, server logs, and metadata reports. Elena's legal team worked late into the night, combing through records, looking for the single piece of evidence that would prove her case. It was Simone Yates who found it. She was sitting in Elena's small office, surrounded by printed emails and highlighted contracts, when she noticed something in the metadata of the transition agreement. The document had been created on March 17th at 11:47 a.m., but Elena's digital signature had been applied at 10:22 a.m., more than an hour earlier. Yates sat back in her chair, staring at the screen. "Elena," she said quietly, "you signed before the transition agreement even existed." Elena looked up from her laptop. "What?" Yates turned the screen toward her. The file creation timestamp. The transition agreement was finalized at 11:47. You signed at 10:22. You couldn't have signed a document that didn't exist yet. Elena felt something shift inside her, a weight lifting, a clarity returning. "I signed the framework." "You signed the framework," Yates repeated, "and someone applied your signature to the transition agreement after the fact, either through error or intent." Elena stared at the timestamps. "They used my signature from the framework." Yates nodded. "We need to present this to the judge." Elena thought back to that day in March, 14 months ago. She'd been in her office, reviewing the framework agreement. It had been straightforward. A preliminary document outlining potential governance structures, all contingent on further discussion and approval. She'd read it carefully, noted the conditional language, and signed it electronically through the company's standard document platform. She remembered the exact moment. It had been morning, before a product launch meeting. She'd signed quickly but deliberately, trusting that the document said what it claimed to say. She'd never seen the transition agreement. Not that day, not in the weeks that followed. The first time she'd encountered it was 6 months later, when Hale had mentioned the transition framework in passing during a board meeting. She'd assumed he meant the original document she'd signed. It wasn't until the legal notice arrived that she'd realized what had happened. "They substituted the documents," Elena said slowly. "They took my signature from the framework and attached it to a completely different agreement." "That's what the metadata shows," Yates confirmed. "Your signature timestamp is earlier than the document creation. That's impossible unless the signature was copied from another file." Elena closed her eyes briefly. Relief mixed with frustration. Relief that she could prove the truth. Frustration that it had come to this. "Can we verify it's the same signature file?" she asked. "Already did. The digital signature hash matches exactly between both documents. It's not just similar, it's identical. Same signature, applied to 2 different documents. That only happens if someone copied it." Elena opened her eyes. "Then we have them." "We have them," Yates agreed. The courtroom felt different the second time. Judge Holt reviewed the metadata report in silence, her expression unreadable. Calloway stood beside his table, his confidence visibly diminished. "Mr. Calloway," the judge said, "can you explain how Ms. Mirren's signature appears on a document that was created after she signed?" Calloway glanced at his team. "Your Honor, it's possible there was an administrative error in the file versioning. The content was agreed upon. The signature was valid. The timing discrepancy is procedural, not substantive." Judge Holt looked at him over her reading glasses. "Procedural errors in contract execution are substantive, Mr. Calloway. If Ms. Mirren signed one document and her signature was later applied to another, that's not a valid contract." "Your Honor, the terms were discussed. Ms. Mirren was aware. Awareness and consent are not the same thing." The judge's voice was firm but not unkind. "If she signed a framework agreement that outlined conditional terms and you applied her signature to a transition agreement with binding terms, that's misrepresentation, whether intentional or not." The room was silent. Elena sat perfectly still, her heart steady. She'd known the truth, but hearing it validated felt like breathing after holding her breath too long. Judge Holt closed the folder. I'm ruling in favor of Ms. Mirren. The transition agreement is void. The framework agreement remains the operative document, which means any governance changes require mutual approval. The board's unilateral removal of Ms. Mirren is reversed. Calloway opened his mouth, then closed it. Across the room, Marcus Hale's expression was unreadable. This case is dismissed, the judge said. Ms. Mirren, your position is reinstated. The gavel came down. For a moment, no one moved. Then the courtroom began to empty. Elena remained seated, letting the moment settle over her. She'd won. Not through theatrics or courtroom drama, but through the simple, undeniable truth of timestamps and metadata. Through her own careful record-keeping and the logic of digital files. She'd won because she'd been right. Simone Yates touched her shoulder. Ready to go? Elena nodded and stood. Elena stood outside the courthouse. Simone Yates stood beside her, holding a briefcase full of documents they no longer needed to defend. You knew, Yates said quietly. You knew what you signed. Elena nodded. I keep records, every draft, every version, every note. I learned that early. Most people don't. Most people trust too easily. Elena's voice wasn't bitter, just factual. I trusted the work. I didn't trust the process. Yates smiled faintly. What happens now? Now I go back, and I make sure the board understands what governance actually means. Will they challenge you? Maybe, but I have the framework, and the framework requires mutual approval. Elena's voice was calm, but beneath it was steel. They'll need to work with me, or they'll need to leave. Yates nodded. You could have settled, Yates said. They offered terms. I know. Elena adjusted the strap of her bag. But settling would have meant agreeing that I signed something I didn't. I built that company. I'm not going to let anyone rewrite what I agreed to. Not everyone fights that hard. Elena looked at her. Not everyone has to. But I did. They parted ways on the courthouse steps. Elena walked to her car. She sat in the driver's seat for a moment before starting the engine. Justice, she thought, wasn't always dramatic. Sometimes it was just metadata and timestamps. Sometimes it was just being thorough enough to prove what you already knew. Sometimes it was just refusing to let someone else write your story. She drove back to the office. 3 months later, Elena sat in the same boardroom at the same table. The composition had changed. Marcus Hale was gone, his shares redistributed. 2 new board members had been appointed, both with backgrounds in long-term strategic growth rather than short-term exits. Diane Kessler remained, her loyalty no longer divided. The company was stable. Revenue had climbed. The team was focused. Elena opened the meeting with a single document, a revised governance framework, co-authored with the board, signed by everyone with timestamps and version controls clearly marked. This is how we move forward, she said, transparently, together, with integrity. No one objected. The meeting proceeded through quarterly results, product roadmaps, hiring plans. The conversation was collaborative, thoughtful, focused on building rather than controlling. When disagreements arose, they were discussed openly, resolved through consensus rather than power plays. This, Elena thought, was what a board should be. After the meeting, Elena stood by the window. She thought about the courtroom, the timestamps, the moment when the truth had been undeniable. She thought about the board that had tried to remove her and the judge who had listened. She thought about the difference between what people say you agreed to and what you actually signed, And she thought about the quiet power of keeping records, of knowing your own truth, of refusing to let anyone rewrite your story. Elena turned away from the window and walked back to her desk. Her laptop waited. Email notifications blinked in the corner. A product demo was scheduled for later that afternoon. The team was waiting for her feedback on a new feature set. There was work to do. The kind of work she'd always done. Building, creating, leading. The kind of work no one could take away with a forged signature or a board vote. She sat down, opened her laptop, and began to type.